In the fall of 2024, something happened inside American motorsport that most people missed entirely. The mainstream press reduced it to a headline. But beneath that headline was a structural rupture, one that had been building for years. 23XI Racing, the NASCAR team owned by NBA legend Michael Jordan and veteran driver Denny Hamlin, filed a federal antitrust lawsuit against NASCAR itself. Not a complaint, not a quiet grievance. A federal lawsuit alleging that NASCAR operates as an illegal monopoly, one that controls who competes, who profits, and who gets left behind. Drivers responded. Team owners spoke out. People who had quietly accepted the rules for decades suddenly found their voices. Ask yourself 3 questions. Why would a team owned by one of the most recognized athletes in American history, take this kind of risk? What does it mean when competitors openly challenge their own sport's governing body in federal court? And what does this reveal about who actually holds power in American professional sports? This is not simply a sports story. This is a story about market control, economic exclusion, and who gets a seat at the table. That story plays out in America every single day. To understand what is happening now, you have to understand how NASCAR was built and who built it. NASCAR was founded in 1948 by Bill Franceschetter in Daytona Beach, Florida. From day one, it was a privately held organization, not a public company, not a democratic federation, a private entity run by one family, the France family. And for decades, that structure was simply accepted. Compare that to Formula One, which operates under the regulatory authority of the FIA, an international governing body with formal oversight processes. NASCAR has no equivalent. The sanctioning body is the league. The league is the business. The business sets the rules. For most of NASCAR's history, teams tolerated this arrangement because the sport was growing and the money was flowing. But the charter system introduced in 2016 created a new fault line. Charters were supposed to guarantee race entries and revenue sharing. They were supposed to provide financial stability. Instead, teams discovered that charter value was entirely at NASCAR's discretion, with no independent arbitration and no transparent process. For years, owners complained privately. They negotiated. They accepted uncomfortable terms because the alternative, not racing, was worse. What changed in 2024 is that 2 teams decided to stop accepting. And they took that argument to a federal judge. At the center of this dispute is a concept most sports fans have never had to think about: monopsony power. A monopoly is one seller controlling a market. A monopsony is the mirror image, one buyer controlling a market. That is exactly what 23XI Racing and Front Row Motorsports allege in their lawsuit. Here is how it works. NASCAR controls the charter system. The charter system determines which teams can compete in Cup Series races and receive guaranteed revenue. Without a charter, a team has no financial certainty. Operating without one at the elite level is economically unviable, so teams need charters. And NASCAR is the only entity that issues them. This means NASCAR effectively sets the price of participation. It sets the terms. It determines how revenue is distributed. Because there is no competing series of comparable stature, teams have no real leverage. They accept NASCAR's terms or they leave. The lawsuit argues this violates the Sherman Antitrust Act, that charter agreements contain provisions protecting NASCAR's market position and preventing competitive alternatives from emerging. This is not an exotic legal theory. It is the same framework used against tech companies and pharmaceutical distributors. The question is whether a federal court will apply it to professional motorsport. What happens in a courtroom never stays in a courtroom. Disputes of this magnitude send signals to sponsors, to broadcasters, to investors, and to athletes whose careers depend on institutional stability. When 23XI filed its lawsuit, NASCAR responded swiftly. The organization declined to issue provisional charter agreements to 23XI's expanded roster for the 2025 season. That decision had immediate consequences. Driver contracts were affected. Sponsorship negotiations became uncertain, and a message was sent to every other team owner: challenge the structure, and the structure will respond. Television partners like Fox Sports and NBC have broadcast deals worth billions of dollars. Those deals assume a stable, predictable racing product. Sponsors invest in teams based on projected exposure and competitive access. If a court destabilizes the charter system, the entire financial architecture of the sport becomes uncertain. The clearest parallel is European football's proposed Super League in 2021. 12 powerful clubs attempted to form a breakaway competition. The backlash was immediate: fan protests, government threats, UEFA sanctions. Most clubs withdrew within 48 hours. But the underlying tension between governing body authority and club economic ambition never disappeared. It went underground. NASCAR is living through a version of that same tension right now. When this story broke widely, much of the coverage framed it as a personality conflict. Michael Jordan versus NASCAR. Denny Hamlin picking a fight with the establishment. Some outlets highlighted the racial dimension, noting that 23XI is one of the few black-owned teams in NASCAR's modern era. Those dimensions are real and worth examining. But reducing this story to personal grievance or identity politics misses the structural argument entirely. The central misconception is this: that 23XI Racing is behaving badly. That filing a federal lawsuit is unsportsmanlike. That Denny Hamlin's public criticism is the act of a disgruntled competitor seeking unfair advantage. This framing is emotionally simple, but it inverts the actual sequence of events. The lawsuit came after years of failed negotiation. It came after 23XI's attempt to expand from 2 cars to 4 was met with institutional resistance. It came after the organization concluded that private negotiation was structurally incapable of producing a fair outcome. The real story is not about one team's ambition. It is about whether private sports governance in America is subject to the same legal constraints as any other industry. That is not a niche sports law question. That is a question about how power operates in America. Look 5 to 10 years forward, and 3 scenarios emerge. None are inevitable. All carry real consequences. The first is a negotiated settlement. Federal antitrust litigation is expensive and slow. Both sides have incentives to resolve this before a judge issues rulings that destabilize the entire charter framework. A settlement would likely bring revised revenue, sharing terms, and more transparent processes. Incremental change, but durable. The second scenario is a court ruling in favor of 23XI. This would be significant. It could void elements of charter agreements across the sport, trigger renegotiation of broadcast and sponsorship structures, and open the door for alternative racing series to compete more aggressively. That competitive pressure might benefit fans long term, but years of institutional uncertainty would come first. The third scenario is NASCAR prevails. The court finds no antitrust violation. The structural dynamics continue unchanged, and the chilling effect on future challenges becomes real. What all 3 scenarios share is this: the question has been asked publicly in federal court in a way that cannot be unasked. The governance of American motorsport will never again be fully insulated from this kind of scrutiny. That itself is a form of permanent structural change. You might be wondering what a NASCAR lawsuit has to do with your daily life. Here is the honest answer: more than you might think. The mechanisms at work here, private governance, market exclusivity, antitrust law, appear throughout the American economy. In the gig economy, where platforms set the terms for millions of workers. In healthcare, where networks determine access and price. In tech, where dominant platforms control the conditions under which smaller competitors operate. The 23XI lawsuit is a test case. It asks whether antitrust law, designed over a century ago to prevent monopolistic abuse, can address modern forms of market control. The outcome will be studied far beyond the world of motorsport. For viewers who want to stay informed, here is what to watch. Follow the federal docket. Milestone rulings will signal direction. Watch how other team owners position themselves as the case develops. Watch whether broadcasters or sponsors publicly align with either side. And watch whether Congress takes interest. Antitrust enforcement has become increasingly bipartisan. If this channel is giving you structural context that daily headlines cannot, consider subscribing. We cover the mechanisms behind the stories, not just the stories themselves. Step back from the courtroom. Step back from the racetrack, and consider what this moment truly represents. It represents something that occurs in every era of American institutional life, a point where informal rules that governed a system for decades come into contact with formal legal structure. A point where the question is no longer whether something is traditional, but whether it is lawful and fair. This is how institutions actually change, not through dramatic collapse, through slow, contested, legally mediated pressure. The same process that reshaped labor relations a century ago, the same process working through technology and artificial intelligence today. NASCAR is not just a racing series, it is a cultural institution, part of how millions of Americans experience competition and community. When that institution is challenged, not by outsiders, but by the people who built it from the inside, it tells us something important about where the real pressure points of American life are. Resist the simple story. Resist the villain and the hero. Follow the structure. Follow the incentives. Follow the legal language. Because the world does not change through headlines. It changes through the slow, unglamorous process of institutions being held accountable to rules that were always supposed to apply. That process is underway, and it is worth paying close attention to.